Welcome to the Ending Sexploitation podcast, where we decode sexual harm and provide you with active solutions. I'm your host, Kaylee McNamara.
Well, hello. Today, I am so thankful to be talking with two guests, Lisa Haba and Peter Gentala, both of whom are lawyers working on a case to sue Twitter for facilitating child sexual abuse materials, CSAM for short, otherwise, and I think legally known as child pornography and sex trafficking. So thank you, Lisa and Peter, for joining us today.
Thanks for having us.
Thanks.
This topic of Twitter and child sexual abuse is obviously so important and has so many ripple effects, but I really want to dive into this. But before we do, could you maybe both introduce yourselves and tell a little bit about your background for those who aren't familiar?
Well, good morning, Haley. Thanks for having me. My name is Peter Gentala, and I am a senior legal counsel with the National Center on Sexual Exploitation Law Center. And we focus on all the ways that sexual exploitation is connected in our culture and across the world. And we're particularly focused on sexual exploitation that happens online. We're a connected society, and a lot of the ways that exploiters seek to harm people involve the internet. So what we're trying to do is bring the most robust form of legal accountability to the internet as possible. And it's a big job, but it's something that's really important. And this case is a great example of that.
Hi, good morning, Haley. Thank you so much for having me on your podcast here. My name is Lisa Haba. I am a partner at the Haba Law Firm, and we are based in the Orlando, Florida area. Our firm, I started my legal career as a criminal prosecutor in Central Florida. And I spent approximately 8 years as a prosecutor focusing on human trafficking, sexual abuse against children and women, and other crimes that would fall under either the internet crimes against children or things of that genre. When I left the prosecution and we opened our law firm to begin targeting human trafficking and sexual abuse at the civil side, a big part of that was because we saw a rampant amount of abuse happening amongst legitimate businesses and entities that were letting it happen in plain sight. And that includes internet platforms such as Twitter. And as part of our law firm's mission is to go ahead and eradicate that from society and work hard to bring justice to our survivors.
Wow, well, it's obvious why you two are working together. I just see how both of your missions are so perfectly fitting together. I think online sexual exploitation, particularly of children, has been on people's minds more so this last year, probably than ever before, with the child sexual abuse materials, or CSAM, have actually surged over 106% during COVID, according to the National Center on Missing and Exploited Children. And other research, I think that came out this year or last, found that online grooming for children for sexual abuse can actually sometimes take less than 20 minutes. So I think there's just so much more awareness about this right now and more research coming out about it. But still, and this goes a bit to what you were saying, Lisa, I think most people assume that this kind of thing isn't happening on the big mainstream social media companies. Like companies like Twitter, they think are mostly safe. And maybe if something like child sexual abuse gets uploaded, they remove it really quickly. But that wasn't the case in the lawsuit that you're both working on. So can one of you maybe tell me a bit about the story of what happened with this case?
Go ahead, Lisa.
Okay. Sure, I'd be happy to. This was a tragic story. Back in January of 2020, a mother found out that her son, John Doe, was about to take his own life. And she found that out from a family friend. And that sort of opened up a dialogue that sparked this lawsuit. And what it turned out had happened was John Doe, when he was 13 years old, was on Snapchat and was talking to somebody he believed to be a friend from school, somebody that he actually knew. And in fact, what it was instead was a trafficker posing as a 16-year-old girl. Well, conversations ensued, And during the course of those communications, there was ultimately an exchange of videos and photos between a 13-year-old boy and who he believed to be a 16-year-old girl down the street. What the reality was is that the traffickers used classic grooming tactics and highly manipulative tools to entrap this 13-year-old boy and his friend, and that would be John Doe number 2, who were talking to them and convinced them not only to send these things, but then immediately turn this into a sexploitation case. And by that, I mean, they used these images, these videos, and said, if you don't do X, we will release these to your parents, we will release these to your coach, we will release these videos to your pastor, the people in the community that you know, love, and care about. And as a result of that, as a result of the fear of that happening, to a 13-year-old boy, their reputation is everything. Their reputation is their world. And so where as an adult, we'd say, who cares? To a child, it matters everything. That is everything to them. And so as a result of this, they complied and continue to provide videos and footage out of fear of the consequences if they fail to do so. Well, fast forward to some time passed, and the traffickers wanted to meet the boys, wanted to meet up. And thankfully, the boys were smart enough to say no. They avoided the situation and they did not become ensnared in further into the world of human trafficking. Now, they thought this misery and this horrible thing was over. They thought this was behind them. And then at 16 years old, it resurfaced on Twitter. And it began surfacing as a compilation video of the sexual acts of these 2 boys amongst their friends in the high school, amongst their peers, amongst everyone they knew. And the amount of social anxiety, fear, harm to these children, psychological, financial, physical, was tremendous. In 2 days, 167,000 times, this video of child pornography, of child sexual abuse material was viewed. It was retweeted over 2,000 times. That was on day 2. Over the course of the time that it was online, this boy told his parents, and he and his parents both reached out. John Doe number 1 reached out to Twitter and said, this is CSAM. I was a 13-year-old boy. They provided his license to prove his age. And he said, look, I was a child then, I'm a child now, but please take this down. This is illegal. And Twitter's response after back and forth was, after being made aware of exactly what the nature of the videos were, as well as the age of the child, and both children, in fact, they said, we're not going to take it down because we don't think it violates our policies. So Twitter was given the opportunity to act. They were made well aware of the nature of the materials on their platform, and they chose to maintain those videos, to maintain their presence, allowed them to be retweeted, allowed them to be shared, viewed, and allowed criminal conduct to go unchecked in plain sight on their platform. And more horrifically, they profited from it. They profited from the advertising, they profited from the media, they profited from the dissemination of the data that they harvest from these websites and the users. They made money off the sexual exploitation of a child. So our lawsuit is here to hold Twitter accountable and to say that this cannot happen in plain sight, and we have to say no to child exploitation.
Oh, it's such a heartbreaking and horrific story. I mean, the fact that Twitter said that these child sexual abuse videos didn't violate their terms of service, allowed them to remain up, it's just so inconceivable to me. I mean, so you've filed this lawsuit. Has Twitter specifically addressed that in any of the legal motions or conversations that have followed? Did they claim it was a mistake, or have they just ignored the fact that they knew, presumably, that this was child sexual abuse material on their platform?
Well, that's a really good question, Haley. We're still at a very early stage of the lawsuit, so Twitter hasn't spoken directly to the allegations very much. They have alluded to them in a filing, and right now they're speaking about things in a very general way to the court. They're talking about things like the volume of communications on their platform. They're talking about the way that they have to go about managing and policing that platform. They've alluded to the fact that human error is a possibility. So we're waiting for them to actually speak directly to the facts, and really understand what their position is. But right now, because of the way they're approaching their legal strategy, they're hoping that the court will embrace a broad concept of legal immunity. They're choosing a legal defense that they hope will prevent this case from ever going to trial. They're trying to basically avoid interacting with the facts in this case. And so at this point in time, we're not seeing a lot of interaction with the direct facts. Instead, they're choosing to use kind of a procedural defense. And we can talk about that more, about how they're going about doing that, because that's one of the major problems that has allowed sexual exploitation to proliferate on the internet.
Yeah. One quick question before we go into that, because I think that's so important to dig into further, is, I guess, why do you think it's important to sue Twitter specifically for this? Because of course, the traffickers, the abusers who groomed and exploited these young people should be held accountable. And why also do you think Twitter should be held accountable?
That's a great question. Yeah. Well, there's more than one harm that has happened to John Doe 1 and John Doe 2. In the first instance, they were harmed extremely by the individual or individuals. Probably it was a group of people that were using the internet to sexually exploit them and profit from that sexual exploitation. So that's clearly harm, and those traffickers should be held accountable, both criminally and civilly, to the extent it's possible. And unfortunately, the criminal case against those traffickers has not been able to move forward. That investigation has kind of hit a roadblock, and there's no guarantee that it can be rekindled. But the second harm was when Twitter was given all the information that a reasonable internet platform would need to understand that there was child sex abuse material being disseminated on its platform at a broad scale. We're talking about, in all likelihood, millions of views of children being sexually exploited. So once a large internet platform, and I might add one of the wealthiest companies in the world, one of the biggest companies in the world, and a company that specializes in connecting people, once they understand that their platform is being used that way, once they have full knowledge about that, they need to take responsible action. And this case is important because it's not a case where we're focusing on Twitter's failure to detect it. The victims themselves detected the material for Twitter and gave them the information. And so they just provided them a very simple, a simple request. They were pleading to take their sex abuse videos off of Twitter, and Twitter just ignored that. And so when you have that kind of decision to ignore it, and even initially refuse to take the most harmful material you can imagine down from your platform, that's where there needs to be accountability to follow up and challenge that, because that's not reasonable. It's not appropriate under any scenario.
Yeah.
And along the same lines, that's just not the view of the lawyers in this case. That's the view of Congress. Congress changed the law in 2008. We had a Trafficking Victim Protection Act that allowed civil lawsuits to be brought against a perpetrator. Well, in 2008, Congress changed the Trafficking Victims Protection Act to allow a new or should have known standard that allowed for financial accountability to businesses and to entities and to those that should have known and failed to act, or did know and failed to act, as in this case, which is far, far worse. Now, in addition to that, in 2018, Congress looked at the Communications Decency Act, which I'm sure we're going to get into here, but they said, wow, the internet is being used in a nefarious way. The internet is being used to allow and enable sex traffickers to operate in plain sight. And the websites that should be stopping it just aren't. They aren't taking the steps that are necessary to protect children. So we, Congress, are going to step in, and they passed a law we now know as FOSTA SESTA. And what FOSTA SESTA basically did is it creates a duty to websites to monitor their own platforms, a duty to websites to say, to look for human trafficking specifically, and to make sure that they are not only policing for it, but they're stopping it when they find it. And so in this case, just as Peter said, they were notified by the victims about this, and they still failed to act, which is absolutely a breach of federal law as well as their duty to our clients.
Mm. This leads perfectly into this next question, Lisa, which is, what are the legal challenges with this case? These two laws that you just cited, it seems like it should be kind of open and closed case. But it seems like social media companies have some presumptions of immunity from liability here. Could you maybe unpack that a little for us?
Peter, you want to go ahead?
Well, sure. The challenge that many, not just in this case, but unfortunately, really across the internet, is there's a provision of federal law that's part of a much broader bill called the Communications Decency Act, known as Section 230. And it's shorthand. Our listeners, I'm sure, are going to recognize that from one context or another, because it comes up pretty much anytime people are disagreeing on the internet. Mm-hmm. And that disagreement could spill over into the courtroom. Section 230 is actually a short provision, and it really focuses on the responsibility of internet platforms when something harmful or obscene or objectionable is on their platform. It's on their own website. And it's the idea of it is, it was part of something called the Communications Decency Act. So Congress was concerned about harmful content on the internet, and wanted to equip internet companies with a way to address that, and then not face legal ramifications when they do address it. Over the years, though, the Communications Decency Act, over about a 20-year period, has turned into something quite different, which is a very broad, all-encompassing form of immunity, where if the decision is about information on their platform, and if that information or that content has been created by someone else, internet companies have been arguing for and receiving in the federal court system a complete shield to liability. So let me give you an example. One of the main provisions of Section 230 is even titled by Congress the Good Samaritan provision. And the idea of it is, a good Samaritan, you step in and do something good for someone else out of concern for their well-being. Well, so Congress designed that so that an internet platform would not be held civilly liable for a decision to take down harmful content, obscene content, other forms of harmful content. Well, what companies have been arguing now in the court system is, well, this covers our whole decision. So if our decision is to leave it up, if our decision is to do nothing, if our decision is to, in the case of Twitter, allow child sex abuse material to just proliferate on our platform and indeed become the preferred large social media platform for people to trade sexual abuse material, then that's our decision. And Congress wanted us to be completely free from any civil liability for that. That's a drastic misreading of Section 230, but it has found some purchase in the courts. And so that's the concern. That's really what the legal case is going to focus on initially. And in the internet world, in the world of the law, focusing on the way the law connects with communications on the internet, there are so many conversations that are about 230. One of the reasons you might ask, well, how is it that the courts would even embrace that kind of an interpretation? How could they be so far from what Congress hoped to have happen? And part of the reason is because the Communications Decency Act started at the very beginning of the internet. And so many applications of the way the internet works, about the way we all are connected in society, were not even anticipated at the time that the Communications Decency Act was written. And there is some language in the beginning kind of congressional findings that talks about fostering innovation and that type of thing. And so what the courts have so far focused on is that idea that it's important to foster an environment of innovation on the internet is more important than the safety side of what Congress was focused on. So there's going to have to be, and there really is, there's new cases every day. A very important case was just handed down yesterday by the Ninth Circuit that focuses on the connection between product liability and Section 230. Up until now, claims for harmful, dangerous products were getting blocked by this immunity on almost a routine basis. And the Ninth Circuit expressed latitude that under the right set of circumstances, product liability claims can move forward, and Section 230 isn't a bar to that. So this is an area of law that is just unfolding case after case. It's taking a long time. As a matter of fact, it is so piecemeal the way the law has been developing. Justice Clarence Thomas has written a separate opinion, basically urging that the litigation continue so that the Supreme Court can speak definitively to some of these things. Because the Supreme Court, while there's a lot of cases out there, there's nothing definitive from the Supreme Court about how this important provision can work. So there's a lot there, but it's probably the most important focal point when it comes to the internet law in general. And this lawsuit is very important because it hones in on the heart and soul of what Section 230 was about in the first place, which is keeping people safe online.
It's fascinating how this case really is just at the cutting edge, it seems, just like you said, is kind of evolving how the courts are going to deal with these questions online. And I know there's a lot of kind of different debates around Section 230, what a company should or shouldn't be liable for. But it seems like pretty basic common sense that at least doing some baseline effort to remove sex trafficking and child sexual abuse from, social media platforms. I think everyone can probably agree on that. Aside from, maybe the most absolutist people who don't really care about curbing that kind of material. Have you, in the course of this lawsuit, have you learned more about the general scope of the problem of child sexual abuse on Twitter? From what you've seen, is the John Doe's case an anomaly? Is it symptomatic of an ongoing larger problem with Twitter?
Haley, that's a great question. And I wish I could say it's an anomaly, but unfortunately, our research has shown us that Twitter is the to-go preferred platform of individuals that would trade in CSAM material in the open web. So it's one of the reasons for that is when you go on to Twitter, they strip the metadata out of the images. So part of that's done legitimately for protection of individuals. If your child posts a picture where they're at, you don't want somebody to be able to figure out the geolocation of that child. We fully understand why it's being done. But at the same time, if you post a CSAM image, the identifying information, aside from it being attached to a profile, is stripped from the image. It also doesn't show up in search history results. There's a number of reasons why a lot of pornography ends up on Twitter. And wherever you have a massive amount of pornography, you of course have many people that look at and participate in age appropriate pornography. You also have people that go to the deviant side of that and look at violent pornography of rape videos and child exploitation videos. And because that is a big part of what is showing up on Twitter, our research has shown that we've looked at known hashtags that are used to trade child pornography on Twitter. Hashtags that we have listed in our complaint. I'm not going to say them here because I don't want to disseminate what they are, but when you pull up those hashtags and you go into a search engine for it, the Twitter search bar actually suggests words to help your search better target what you're looking for. Wow. So imagine our horror when we put in one of those hashtags to see what came up in the search engine, suggested phrases, and along with it, this suggested phrase was young. So they're literally helping people that would consume CSAM material to find an additional word such as young to help hone in their search and find a better dissemination of that illegal material. Furthermore, we found that on Twitter, there not only are these known hashtags, but we have evidence that these hashtags have been sent to Twitter. Twitter has been made aware that these are solely used for the purpose of dissemination of CSAM material. There's no legitimate purpose to their existence. And Twitter has refused to remove those hashtags. We have found evidence that not only are people reporting CSAM accounts and CSAM postings to Twitter on a routine and frequent basis, but these postings are in large part being ignored. We've had users and extensive research done showing that there's actually potentially a percentage of the CSAM material reported that's being taken down. Not all of it, but a percentage of it, which is interesting if you really think about it, how much money and revenue is derived from viewing CSAM material on Twitter. Twitter makes a phenomenal amount of money from doing this. They have ads strategically placed throughout these feeds where they're discussing a pornographic image of a child. And every single time those ads are viewed, every time more people use Twitter, every time more ads are clicked on, the bigger the usage, the more money for Twitter. And so as a result of that, what we're really talking about is Twitter has found a way to profit and monetize the viewing and dissemination of child pornography, and that just can't stand in society.
Wow, that's so horrific. I can't believe that they haven't been sued earlier, or that they haven't been sued successfully 100 million times. Hearing about all of this, it's interesting. Our organization, the National Center on Sexual Exploitation, also has a Dirty Dozen list where we name 12 mainstream companies that contribute to normalize sexual exploitation in some way or another. And my work on this list has led me to being in meetings with different social media companies, including Twitter briefly. And it's been interesting, just my non-legal experience has been with other platforms. They've been far more interested in what we've had to say when we've brought to them concerns, when we've asked them maybe to make some changes to the way that certain app functions worked in order to help protect the vulnerable, particularly children. It was interesting that I personally just felt a colder reception from Twitter compared to some of the other sites. So hearing this also just kind of adds even more of a dark tinge on that experience. What
you would expect, I would say, Haley, you would expect that, they say with great power comes great responsibility, right? Twitter's a Goliath in the internet community. You would think of all people, they would stand up and try to be the gold standard of the protection of children and avoiding the dissemination of such illegal material.
Exactly. And I think, of them as very technologically forward as well. And I know some smaller companies right now that are filtering companies that are working on proactive algorithms that can remove child sexual abuse materials that hadn't even been previously identified before. So this kind of technology is developing, but it doesn't seem to be being embraced by Twitter and similar companies.
And recently, this year, when you think about when Twitter has made the headlines, it's been for being proactive. It has really stepped up its policing, its management focus for content on its platform. It just hasn't used those powers for good when it comes to sexual exploitation. It's famously banned the president of the United States from its platform. It's stepped into a lot of political discussions. It's done many different things, often with the justification of public safety being the focal point. Yet when they're presented with a clear public safety priority, protecting the innocence of children, protecting children from online sexual predators, this is an area where we don't see them proactive at all. We see them at best reactive, and in the case of our clients here, not even reactive. They're just refusing to take down something, and it really took the federal government stepping in to get them to take down the videos. One thing we just want to reiterate: Twitter is popular because it works. It allows for an initial communication and then echoes, reverberations of that communication, retweets. So when we think about what John Doe 1 and John Doe 2 have gone through, it really is impossible to contemplate the level of distribution. When something is up on the Twitter website, we see some view counts that shows us that hundreds of thousands of views and a number of retweets. It's really, we can't put that into a hard number, because think about the ways that can be through the retweeting, through screen captures, through delivery on other platforms, downloading to websites. Really their abuse has been sent all over the place. So this is a special responsibility, is what the point we're trying to make when it comes to Twitter. If you're going to make a platform that gets communications out there and then allows them to continue to reverberate, to keep being sent out over and over again, to magnify the voice of users, when you know that there is harmful criminal material, you have got to step in immediately so that process stops. And the abuse can be cut off, at least at the place where it is, instead of keep continuing throughout the internet.
And especially, I think, when you just think about the added trauma, not only did these poor boys and so many other people that, we haven't even identified who have had similar experiences with Twitter, not only did they experience one time in their life that was exploitative, but then to have that go on. And I've spoken with many survivors who their videos have kind of lived on social media, including Twitter, and just the ongoing trauma that people are continuing to engage with that material. And clearly, in the case of one of these John Does, his mental health was so severely affected, and no wonder. So yeah, the duty of care is just clearly not being met here. Knowing all of this, what can people do if they or someone they know has experienced something similar on Twitter or other sites? Would you have any starting places for them?
Well, the first thing I would say is they need to reach out to Twitter and tell Twitter about what needs to be removed. They have to make Twitter aware of what the issue is, so that Twitter can take the appropriate action in a perfect world, and hopefully they will in the future. It is our high hope that this will be a one-time situation that never repeats again. But notify Twitter through their platform about the image. They'll probably be asked a question about the age and verifying the age of the individual involved, which is completely appropriate to provide that verification. And then we'll see what Twitter's response is. And hopefully Twitter will do the right thing. Hopefully all social media platforms will do the right thing. But if they fail to do that, if you notify them about CCM material on their platform and they fail to act, please feel free to call us. You can call the Haba Law Firm, 844 Haba Law, which is 844-422-2529. Or of course, you can always call NCOSI, and I'll let Peter provide that information.
At the National Center on Sexual Exploitation, we have a web page that is specifically for this lawsuit also. And we have the lawsuit materials there. We have a little bit more information about the case, and we have contact information for our whole legal team. And we're partnered with the Haba law firm and Lisa on this as well. So that's a way to reach her also. And that website is endsexualexploitation.org, endsexualexploitation.org/Twitter lawsuit.
And I'll include links to both of your sites in the notes on this as well, so people can see there. Aside from this legal case, I'd love to hear from both of you about why, as lawyers, you're working on issues like this. I'm sure contract law or something similar would be less heartbreaking. I would just love to hear from you both on that.
I can speak for myself. I have always felt called to work with children and women that have been abused and exploited, boys as well, of course. I'm not trying to make it all one gender, but we certainly don't have a lot of days where you have a happy story come into the firm. But there is so much joy that comes from helping a person who has gone through such horrific trauma actually get healing from that and actually get justice. Mm-hmm. And so, there is a need in our society to help people like that. And, I have always felt called to do that. I think human trafficking is very misunderstood. I think it's very under the radar, and there's a lot of people that don't fully understand what it means and what it is. And so the more light of truth that we can bring to the human trafficking, the more the shadows move away.
I love the question, Haley, because it's great to kind of just reflect on that. My last role before I came to the National Center, I worked for a nonprofit that focused on child abuse, and one of the services that it offered was what's known as child advocacy centers, which is a special process and a special way that criminal investigations of child abuse can move forward, and so that the criminal side, the goal of the state to bring justice where the law has been violated, can also function in tandem with the healing side, the therapeutic side, recognizing that a victim of child abuse is uniquely vulnerable, and they function as kind of one-stop shops, so that a child doesn't have to be re-traumatized by going to multiple different appointments at a hospital and a police station and to a counselor's office and things like that. So I really appreciate the way that people come together to help children who have been harmed. It's referred to in the field as the multidisciplinary team, but it basically means all the walls come down, all the jurisdictional stuff in the law enforcement world, all the professional boundaries between different experts just seem to kind of melt away, and everyone works together as a team. So I really appreciated that. And I really see the same thing in the legal world when we're working on these issues. I see multiple different gifts, a lot of experiences and backgrounds. Lisa has this incredible expertise as a prosecutor, and she's now using that in the civil system. My background is more on the public policy side, and then working on child safety issues. And so it's neat to see the way all these things are coming together. And then just one other note for me, the cases that went through the Child Advocacy Center centers that I worked with often dealt with child on child sexual abuse, and frequently, in a majority of the cases, I would say, part of the story was pornography, children harming each other after they had viewed or been forced to view pornography. And so I just know that is part of the cycle of sexual exploitation. So being at the National Center is a way that I can move into more of a preventive area. I was on the intervention side before, and it's helpful and it feels better to be focused on prevention.
And hopefully please go.
Sorry, I just want to add one more thing. And for anybody that's thinking about, your own situation and wondering if you should call in, something to consider is this. We frequently hear people say, I don't have enough evidence. I can't prove it. Please understand that's exactly what Peter and I do. That's our job as lawyers, is to find that evidence, and we're good at it. So I promise you that just because you don't, quote unquote, have the evidence doesn't mean you really don't. It just means that we need to vet the case and investigate it thoroughly. So if you have something that happened to you, if you have a harm, feel free to reach out to either my firm or the National Center, and we can help you find the best roadmap to get exactly the evidence you need for your case. You know, if it's there to be found, we'll help you find it. And I also want to say as well that, you know, it has really been an honor and a blessing to work with NCOSE. They have been such wonderful partners in this endeavor, and I have never met such a wonderful group of legal advocates that have really, really put themselves out there with the sole mission of helping survivors. So know that if you call in, you are in absolutely the best of hands.
Well, thank you so much, Lisa and Peter, not only for your time in talking with us today, but for your work. You both are actual superheroes, and I really hope that this case goes the right way and that it helps set precedents that protect so many more Jane and John Does by improving some of these systems at Twitter and hopefully other platforms as well. Thank you both so much.
Thank you, Haley. It's been good to be with you.